License laws and rules of the Ohio Real Estate Commission. Who approves the appointment of the ancillary trustee when a broker has died? So after a broker dies, is it the division? Is it probate court, Department of Commerce, or the commission? Now think about it. Someone has died. All right. Yep. Probate court. So anytime you've got death, think probate. So probate court approves the appointment of the trustee when a broker has died. All right. What law requires a broker's license to be placed in close proximity to the Federal Fair Housing poster? The Ohio Civil Rights Act, Federal Fair Housing Act, Ohio Licensing Law, or Real Estate Settlement Procedures Act? Which one? All right. So yes, it is Ohio Licensing Law. So that one had some confusion. So you all split that one. So Federal Fair Housing poster. So the broker's license to be placed by it. It's Ohio Licensing Law is going to determine where the broker's license has to be. So, you know, the Ohio Civil Rights Act wouldn't have anything to do with the broker's license and where it would have to be. And the Federal Fair Housing Act would just have jurisdiction over this poster, but not this. So it would definitely be Ohio Licensing Law because that's going to determine where an Ohio broker's license has to be placed. All right. Moving on. A closing occurred on September 30th, 2012. Under Ohio licensing law, the soonest the broker can dispose of the file is December 31st, 2012, September 30th, 2014, 2015, or 2019. How long do you have to keep your files? All right, so 3 years. You have to keep your files 3 years. So if it was September 30th, 2012, you would have until 2015 that you have to hold on to your files. Now remember, at any point, if there's a complaint lodged against you within those 3 years or anything like that, they can request all of your documentation. And if you don't have it, then there's going to be a problem. So remember, 3 years is how long you have to hold on to all of your paperwork from a transaction. So anything that was any correspondence, any paperwork from that transaction, that would have to be kept in a file for 3 years. Real estate recovery fund claims are limited to what dollar amount? $2,500, $40,000, $100,000, or $800? Real estate recovery funds. So yes, 40,000. So, you know, I saw somebody put 2,500, and so 2,500 is the amount that the Real Estate Commission may fine you per violation. 800 is the maximum amount of non-interest bearing loan that can be received for pre-licensing classes, and $1 million is the fund. Well, actually I had 100,000, but $1 million is the minimum amount that must be in the recovery fund. So you have to have that as a minimum amount in the recovery fund, but the 40,000 is the maximum that will be paid in the name of a licensee. So the fund claim, so when you're making a claim, that's the limit to what you're allowed to use or claim or be funded. All right. In Ohio, under what circumstances can a real estate broker pay a referral fee to an out-of-state broker? The out-of-state broker agrees to claim it on her federal income taxes. The referral fee is less than $100. Out-of-state broker doesn't perform other real estate activities in Ohio, or the referral fee is less than $200. Right. Out-of-state broker doesn't perform other real estate in Ohio. It has nothing to do with referral fees. It all has to do with whether they do business here or not. So if you're doing a referral with the real estate broker can refer the referral fee to an out-of-state broker. They just can't be doing business in Ohio. Who can be affected by lead poisoning? Children, elderly, anyone, or pregnant women. Right, everyone. Everyone can be affected by lead poisoning. The law was put in place because of children, but everyone can be affected. What must Brett's Brokers team include in their advertising as licensees working in Brett Foster's Ohio brokerage? The brokerage name, the name of all licensed team members, the contact information for each team member, or the names of all team members shown in photos. Yes, the brokerage name. So the brokerage name has to be equal size or larger than the team name. So or the licensee's name. So if you're advertising, you have to make sure that your name is either the same size or smaller than the brokerage name. So that way you won't get fined or caught for that. All right. What type of property is encompassed by Ohio's broker lien law? Is it vacant property zone residential, 4-family apartment complexes, commercial property, or a single family residence? The broker lien law. So yes, commercial property. So we had a split on that one. Single family residence. So a broker lien law is going to be only in commercial. That's not going to happen because you're not going to have a broker lien on residential property. So single family residential is not going to have a broker lien. That's only going to be on commercial property. So if you see the words broker lien, know that it means commercial. All right, some movement on the board. Michaela making her way up. Shy on top. A seller gave her agent a check for getting her house sold so quickly. What must the salesperson do with that check? Give the check back to the seller. Give the check to their broker. Keep the check regardless of the amount. The agent may keep the check if it's less than $10,000. What do they have to do with that check? All right. So yes, give the check to their broker. So you can be paid that way. You don't have to give the check back to the seller. It's just that for any real estate transaction, you must be paid through your brokerage. So whatever money you receive for real estate, you have to then give to your broker so they can then give it back to you. So you always have to be paid through your broker, whether it's a referral fee from an out-of-state referral, anything like that. It all has to go through your broker in order for you to be paid from it. So just remember, your broker is who pays you in transactions, not the clients. They cannot pay you. That is illegal. All right. Woo-wee, Shy with the average answer streak of 6. Nice. Which transaction files from 1 year ago can Edward, an Ohio broker, dispose of? The buyer representation agreement, receipt for personal expenses, completed listing agreement, or terminated listing agreement? What can they throw away after 1 year? All right, we got half the answers. There we go. Yes, personal expenses. Even terminated listing agreements you have to keep, because it still means that you had a contract or you had an agreement with someone. That's a record of a real estate transaction or a real estate deal. So you would then have to hold that for 3 years. So remember, this is your personal expenses. You don't have to hold that for 3 years. You want that for your, well, if it's personal expenses, that's one thing, but if it's a business expense, hold it for your accountant. But yeah, everything else on this list deals with the real estate transaction and must be kept for 3 years. All right, all right, all right. Who does an agent need to notify for a change of his or her home address? The commission, their broker, their local board of realtors, or the division of real estate? Who do you have to notify when you change? Everybody's waiting until they see that open answer. Yes, the Ohio Division of Real Estate. I mean, you could tell your broker, that's nice, but you don't have to notify them. So the Division of Real Estate is who holds your license, and so where you get licensed from. So you need to notify the Division of Real Estate anytime there's a change. Oh, Kev on the move. Kev's like, I'm taking my test next week. I'm getting it. What lien automatically attaches to a commercial property to secure a broker's commission? Attachment lien, a broker lien, a mechanic's lien, or a judgment lien? Come on, anybody who was listening a few minutes ago should know this one. Answer is open. You can see it. Yes, a broker lien. So mechanic's lien is for people who work on the property. So if you were a plumber, contractor, anything like that, you would put a mechanic's lien on the property. But a broker lien, again, commercial property, broker lien. Attach those 2 words in your, or those 4 words into your mind. Broker lien goes with commercial property. All right. The rate of commission that may be changed on the sale of improved property is the rate agreed upon between the buyer and the sales associate, the rate agreed upon between the broker and the sales associate, 6%, or the rate agreed upon between the broker and the property owner. Everybody's waiting. Come on, you guys know this stuff. Yes. It is the rate agreed upon between the broker and the property owner. So you all went with the sales associate. Now, the thing to remember is the sales associate is not on the contract. They may sign it, but they're signing for the brokerage. So anytime you have an agreement between a buyer or a seller, they're always the broker's client, not yours as the sales associate. So the brokerage is who is in the deal and who is in charge of that deal. So the salesperson is not actually part of the agreement. The agreement is between the brokerage and the seller, in this case in a listing, or the broker and the buyer in the case of a buyer agency agreement. So always remember that the salesperson is not actually part of that agreement. They're operating on behalf of the broker. So always on behalf of the broker. And for anybody who joined late, I'm going to go back and put this back in the chat. I'm going to put it in again. These are YouTube videos of the 2020 Ohio State exam and the 2021 Ohio exam, real estate exams. So you'll have both examples there. And then there's also a couple math examples, and then the national portion of the exam by itself. So you've got some YouTube videos that you can watch where they'll go through each question, and these are the actual exams, so the old ones. So just know that they're going to be really close to what you'd have to take for the exam this year. Not much has changed. They just move some questions around, shake some things up, but you've got 2 years of exams that you can go back and look at, and then they'll give you examples of they'll give you the actual exam, give you the right answers, and then they'll go over why those are the right answers. So a really great resource if you're getting ready to take your test. All right, so that's in the chat. Feel free to grab those. I'm going to keep going. Under Ohio law, every listing agency agreement must have the diversity in housing logo, a statement defining the practice of block busting, stating that it is illegal, the company policy for brokerage and dual agency, or a mandatory extension clause. Every listing agency agreement. Block busting. Yes, it must state that block busting is illegal. The company policy for brokerage and dual agency, that's not necessarily on a listing agreement. That would be the dual agency disclosure. So the agency disclosure is where that's going to be talked about. It's going to be your block busting is required under Ohio law on every listing agency agreement. Homosexuality is protected under what federally protected class? Sex, homosexuality is not protected, familial status, or national origin? Come on. You guys know this. There you go. Answer without seeing it. Yes, it is not protected. So homosexuality is not protected under any federally protected class. How many hours of continuing education are required by an Ohio licensee over a 3-year reporting period? Is it 20 hours, 26 hours, 35 hours, or 30 hours? How many hours? There you go. Yep. 30 hours. All right, we have one at 20. Yeah, it's 30 hours every 3 years. So think of it as 10 hours a year. Every year to renew your license, you have to have 30 hours of continuing education. There are lots of free ways to get that. So your brokerage, KW is always offering opportunities for CE. Also, the vendors typically do. You'll have, your inspections companies offering things. Lenders will offer things. So there are all kinds of affiliates that you can also get free CE through. And then there are things that you can pay for. So there's a lot of ways to get CE without having to pay for it. All right, Michaela. At what point must earnest money be deposited into the broker's trust account? Is it immediately, within 48 hours of the terms of the contract, whichever comes first, once the offer is accepted, or according to the terms of the contract? Come on. It's cheating when you can read it. I'm going to take these out. Yes, according to the terms of the contract. So most contracts are going to say it's due upon execution of the contract, or due within a day or so or whatever. But some contracts will say due within 5 days. But really, everything involving a real estate transaction is always going to go back to what does the contract say? Is there an addendum? Whatever the contract states, that's the rule. So always remember, it's whatever the contract states. All right, pulling away, shy. Under what condition can an assistant talk with a client about the terms of an offer? When the assistant has the authority of the agent, when all the agents are out of the office, when the assistant has a license to practice real estate, or when the client does not mind dealing with the assistant. Yes, they have to have a license. They can't talk about any terms or any real estate things to a client. What protected group is covered under the Ohio Civil Rights Law, but not under the Federal Civil Rights Law of 1968? National origin, ancestry, handicap, or sex? I see you all waiting. Wait until it gets uncovered. Yes, ancestry. So ancestry is not covered under the federal civil rights law. It is covered under the Ohio civil rights law. So that is national origin, handicap, and sex are all part of the federal. Because remember fresh corn, so H, the handicap is, the H is handicap, the N is national origin, and then the S is sex. An agent receives an earnest money deposit check of $1,500. It would be considered commingling funds if the agent deposited the check in his broker's trust account, placed the check in his commercial checking account, turned the check over to the seller, or held the check until closing. All right, some confusion there. So remember, commingling is when you mix, so mingle, think mingle, you mix money. And so it would mean that they deposited into an account that was not the trust account. So the trust account is where you want the money to go. The money would have to go into a dedicated trust account. So by putting it into their commercial checking account, they commingled it with their own funds, and so they mixed it with their own money. So turning the check over to the seller is not commingling, and holding the check until closing is not commingling. You don't want to do that, and at the same time, it's not commingling. Commingling is when you mix money. All right. Kev at number 3. Michaela, number 2, and up top we got Shy. All right, so we've got a lot of time, so let's go back. We wanted to do state, so we did the license law. So let's look at brokerage relationships. So we're going to hop into a new game. I'm going to give you a few minutes to join in. While we're doing this, any questions, any things that are concerning to you all? If you're talking, Emily, you're muted. You popped up on my screen, so I didn't know if you were trying to say something. But feel free to come off mute. Feel free to put it in the chat. Any questions, any concerns, anything you want to know about real estate? All right, we got 4 of you in here. All right, that's about what we had before, 5, okay. Anyone else? That's 5 out of the 8. All right, I'm gonna get going. All right, so we're missing Kev. There we go. All right. Brokerage relationships, agency law. Let's get it going. A sales agent is acting as a dual agent. The buyer asks the agent how much to offer for the listing. The agent should tell the buyer exactly what the price to offer, disclose what price the seller would take, not offer this advice, or void the listing. All right, good. You guys are quick on this one. Okay. Yeah, not offer the advice. So if you're acting as a dual agent, think of it this way. If you're working with your client, you can act like a coach and you can help them win the game. If you're in dual agency, you become a referee. You have to be fair and impartial to both sides, because if you tell the buyer exactly what price to offer, then you have knowledge of what the seller would take because you did the listing. So you can't tell the buyer what to offer, and you can't tell the seller what they can counter if the buyer's offer is too low. So you have to be fair and impartial to both sides because you have unfair knowledge of the situation. So remember, you're in dual agency, your obligation is to both clients. So if you help one, you are hurting the other. So always remember that dual agency means you're a referee, fair and impartial. You can't give information to either side that is not just factual information about the market or something other than anything you could know from working with that person. And I appreciate you jumping on and answering the questions. The broker lists the home. This agreement can be terminated by all of the following except death of the salesperson, death of the seller, broker bankruptcy, or death of the broker. So it can be terminated by all of the following except. I see you all waiting, getting those free points. As far as the CompuCrammer, here's the thing. I liked it. I used it. And at the same time, I used it because I was a licensed agent before and I really didn't pay attention when I was going through the thing. I was just kind of hitting the button to move the thing forward because I figured I knew it. And then once I got to where I just took the CompuCrammer over and over. Now, watching the videos, using the books, you're going to be close. Remember, there are 4 parts. 53 out of the 80 questions on the national part are going to be your finances, your contracts, general principles, and practice of real estate. So that's your 4 things out of your, so 53 out of the 80 questions are going to be on one of those 4 topics. So if you study those pretty hard, you should be good there. And then as far as your state, 30 out of the 40 questions deal with the 2 things we're going over right now. Your principal, your general or brokerage relationships, and your license law and regulations. So that's 30 out of the 40 questions on state deal in those 2 topics. And then the 4 topics I just gave you are your national. So, it's really an up to you kind of thing. Like I said, I liked it. I felt really comfortable taking the exam because I had the CompuCrammer, and some of the questions felt like they were the same question I got asked from the CompuCrammer. Now, can you get the same thing by going over those videos? Sure. The CompuCrammer is just giving you the test answers just like this. So, again, that's a however you feel most comfortable question. All right. So, death of the salesperson. All right, everybody got it except one. So death of the and the one is probably because you've missed this word, except. So yeah, all of these things, broker bankruptcy, death of the broker, and death of the seller can terminate a listing agreement, can terminate the agreement, except this one because the salesperson is not actually part of the contract. Which fiduciary duty survives the termination of a real estate listing? Is it confidentiality, financing, obedience, or loyalty? This question comes up a couple times, so it might be important. Yes. So confidentiality, yes. Loyalty, no, you don't have to be loyal forever, but you do have to keep their confidentiality forever. There's only one thing that can break that confidentiality agreement, and that's if you have to go to court, because a court can force you to say what you know. Any other reason is not a valid reason. So confidentiality is forever. All right, Rob on the board. What is not the unauthorized practice of law? Completing a pre-printed sales contract form, preparing a real estate land contract, preparing a real estate sales contract, or preparing a real estate lease. What's not the unauthorized practice of law? Yes, completing a pre-printed sales contract form. So anytime you see the words preparing, it means that you're pretty much writing it. So if you prepare any of these contracts or, leases or anything like that, then that's you practicing the unauthorized, that's you doing the unauthorized practice of law. So if it's pre-printed and you're just filling in the blanks, then that means that, especially if it was, the sales contract form from your firm or the state, then that's okay, because that means that it's all there. You're just filling in blanks. You are not allowed to prepare those documents, though, because that would mean you're creating them. So just know that according to the exam questions, if it says prepare, it means you're writing them. A sales agent represents a seller in a listing. What are the agent's duties to the customer, the buyer? Honesty and fairness, loyalty. Loyalty's in there twice, so maybe it's important. Care and accountability. Honesty and fairness, yes. Honesty and fairness is what you owe to everyone in the transaction. So that's the things you owe without having a duty to that person. You owe them the honesty and fairness. Kayla on the rise again. What duty survives the termination of a listing? Loyalty, obedience, confidentiality, or disclosure? Let's see who remembers. And that's the other beauty of taking these exams, is that, you can go back, because something on a later question will probably trigger your memory, and you can always go back and change previous questions. So yes, confidentiality. So I'm thinking somebody just pressed the wrong one for disclosure, so I'm gonna let that one slide. What is an ethical standard that must be followed by an Ohio real estate sales associate? An ethical standard: treat both buyer and seller equally, treat all people honestly and fairly, treat all people as you would have them treat you, or treat all people with honor and dignity. Now, there's another one we just went over. So remember, a lot of your answers on these are going to give you the answer to other questions too. Yes, honesty and fairness. The relationship in which the agent is placed in the position of trust and confidence is described as implied agency, fiduciary agency, disclosure, or brokerage. Yes, fiduciary. Even though that opened up real quick. Hopefully you knew it and it wasn't just that you read it. TJ with the answer streak of 8. A real estate licensee owes the fiduciary duty of confidentiality to the seller until 1 year after the contract, forever, expires when the contract expires, until paid the commission. Yes, forever, forever and ever and ever, unless one thing. Who remembers what the one thing is? What releases you from the confidentiality?
Court.
Yes. The seller dies during a 90-day listing agreement. What is true? The agency agreement is terminated by operation of law. The broker can sue the seller's estate for specific performance. The agency agreement is still in full force and effect. The sales agent can sue the seller's estate for specific performance. All right. Yes, it is terminated by operation of law. Now remember, anytime someone dies, it's through, probate takes place. So operation of law means that it went through the court. So termination by death means that it went through probate, which is the court. So the agency agreement is terminated by operation of law. So some people have the agency agreement is still in full force and effect. Nope. Seller dies or broker dies, that terminates the agreement. So if the seller or the broker die, now remember the salesperson, they can die and it's still in full force and effect. The broker and seller, not so much. Which would cause a real estate sales agent to lose his Ohio state license? A violation of the canons of ethics, violation of the Board of Realtors Code of Professional Responsibility, violation of the Code of Ethics, or a violation of a minor traffic offense. Let's see, how many picked canons versus code? Or no, we actually had people that picked Board of Realtors Code of Professional Responsibility. So canons of ethics is Ohio law. So remember, the canons are by Ohio, and the Code of Ethics is through the Board of Realtors. The Board of Realtors can impose fines, things like that. They can give you slaps on the wrist, but they don't actually hold your license. They can take away your membership, things like that. They can, do certain things, but they can't take away your license because they don't hold that power. So remember, code is the Association of Realtors. Canons are the Ohio law. So canons, think canons over codes. Canons will beat a code any day. If they're shooting cannons, your code isn't going to save you. So canons over code. When can a broker reveal confidential information about a client? Under no circumstances, never, under subpoena, or when the listing expires. Man, you guys jumped on that one. Way to go. Yes. Someone. So it said, when can a broker? Remember, with court. So if you're subpoenaed, then you're called in by the court. So that's the only time. When a salesperson is offering an overpriced property, he should not quote the price, discourage prospects from looking at the property, quote only the listing price, or tell the prospects what he thinks the price should be. Yes, quote only the price. It's not your job to steer people one way or the other. Your job is to give them the facts and let them make their decisions based on those facts. A consumer guide to agency relationships form must be provided for all of the following except a single family residence, a two-family residence, a condominium, and office building. There's only one that's actually different than the rest. Right. So all of these are residential, and this is commercial. All right. What would not cause a real estate sales agent to lose her license? Violation of the canons of ethics, a felony conviction for embezzlement, a second violation of the fair housing law, or violation of the code of ethics. All right, we just talked about this. See who remembers. Yes, code. So again, the word was not cause a real estate agent to lose her license. So you got to watch those, watch how they word these, because remember, code of ethics won't cause you to lose your license because that's through the Board of Realtors. Fair housing law is a law. Canons of ethics is law. Felony conviction for embezzlement, law. So all of those things would cause you to lose your license except the code of ethics. All right, Kevin's back. Let me let him in the room. There we go. So careful how you read them, because the exam is notorious for that. A buyer should never hear his or her real estate agent say, which of the following? I cannot take that offer to the seller. I cannot act as a dual agent per broker policy. I cannot withhold any offers, even poor ones. I cannot withhold hidden defects. Again, this one didn't even hide the answer. You all should have got this right away. Oh, okay. Still some breakdown. All right. So yes, I cannot take that offer to the seller. So that's, and remember, watch how it's worded. A buyer should never hear his or her real estate agent say which of the following. So they should never hear this, because you have to take all offers to the seller. Your job is to take whatever offer they make. It doesn't matter if they say I want to give them $50 on $1 million property. Still your job. Now you can fire that client for being unreasonable. And at the same time, if you stay in the agreement, your job is to take that offer to the seller. And by saying I cannot withhold any offers, even poor ones, that is the truth. You are telling them the truth. So you should be able to say that. Always check the wording, because I think that's what got a couple people. Who is not an agent or sub-agent? A salesperson employed by a broker, a non-licensed personal assistant of an agent, a broker who has listed an owner's home for sale, or property manager managing property for others. So who is not an agent or a sub-agent? Yes, a non-licensed person or personal assistant of an agent. Remember, property managers have to have a real estate license. And so they are an agent or a sub-agent for the owner. They're acting as agent. So what is not a fiduciary duty of an Ohio real estate licensee? Loan arranging, accountability, care, or obedience. Now, this one isn't covered up. Hopefully you all got it. Okay, loan arranging. So it's not a fiduciary duty. So accountability, care, and obedience are all official duties. Loan arranging is not. So when you think accountability, care, obedience, loyalty, and disclosure. So ACOLD, ACOLD, a cold. Accountability, care, obedience, loyalty, and disclosure. So when you think of your fiduciary duty, think about having a cold. Accountability, care, obedience, loyalty, and disclosure. A broker and seller enter an agreement whereby the sellers owe no commission if they find their own buyer. This type of agreement is net listing, exclusive agent, multiple listing, or exclusive right to sell listing agreement. So if they owe no commission if they find their own buyer, what type is it? Exclusive agency, correct. So exclusive right to sell means that agency is the only one that has the right to sell that property. So if someone else brings a buyer it's still their exclusive right to sell it, and they would be owed a commission. Exclusive agency just means that you're only exclusive with that agency, but whoever brings the buyer, you don't have to pay that agency if you find the buyer. They're just, they're looking for buyers. If they find one, you pay them. If you find one, you don't. X lists a property. X finds a buyer. Is X allowed to write an offer as a buyer's representative? No, an agent cannot collect both commissions. No, it's against federal trade laws. Yes, as long as both parties agree in writing. Yes, if it's specifically written in the offer. There we go. As long as it's agreed upon in writing. All right, let's see how we did. Shy at number 3. Michaela, number 2. Who's coming out on top? And it is TJ. All right, way to go. So again, you've got the videos that I sent. So this is how it looks. It'll basically.
A swing. A swing loan, also sometimes referred to as a bridge or gap loan, is a short-term loan that allows borrowers to borrow against their current property.
So, that's the 2020 exam. So 60 questions with explained answers. Then you got the 2021, 60 questions with explained answers. Then you got real estate math on how to do the math in the real estate. So that's all the videos I gave you. And then also the practice exam 1 through 50 on the 2021 exam. So it goes over all of those. So, and then they do have a second one too. But yeah, so that's, that's it for us today. You've got the information there. We went over the state portion, both sections of the state that are the most important. If there's any questions, feel free to ask now. We've got about 5 more minutes. Feel free to log off if you're done. Otherwise, I'm here for the next 6 minutes to answer any questions that you have.